A major Supreme Court opinion comes out written by Judge Gorsuch. It's in the case of 303 Creative versus Elenis, and it was a 6-3 decision, split right along party lines. And it involves the creation of websites by businesses for people with whom they disagree. In this case, the allegation was that Colorado mandated that business owners provide services for LGBTQ websites, and a business owner who was not interested in making one of those websites wanted to clarify her rights and authorities. Here is the case. It is 303 Creative versus Elenis, and this is a 70-page opinion that comes out of the Supreme Court of the United States of America. And just to see who is drafting this opinion, we see it is Judge Gorsuch. He's joined by Roberts, the Chief Justice, Thomas, Alito, Kavanaugh, and Barrett. They make up the majority, 6-3. Once again, joined by the liberals in the dissent. Sotomayor is drafting this one, and Kagan and Jackson join in. And so let's see what the court held for us after a little bit of background from the head note. Lori Smith is the person who is the subject of this case. Now, she wants to expand her graphic design business called 303 Creative. She also wants to include services for couples who want wedding websites. Making websites out there. But Miss Smith worries that Colorado is going to use a new anti-discrimination act to compel her, in violation of her First Amendment, to create websites celebrating marriages that she does not endorse. Kind of like the cake baker. To clarify her rights, Miss Smith filed a lawsuit seeking an injunction to prevent the state of Colorado from forcing her to create websites celebrating marriages that defy her belief that marriage should be reserved to unions between one man and one woman. So Colorado has this law, and it doesn't sound like anybody has actually asked her to create a website, but there is a law that says the following. In Colorado, it's known as CADA, C-A-D-A. CADA prohibits all, quote, public accommodations, presumably meaning her business, which she doesn't know yet. Is my business a public accommodation? I don't know. But it prohibits all public accommodations from denying the full and equal enjoyment of its goods and services to any customer based on his race, creed, disability, sexual orientation, or other statutorily enumerated trait. The law defines, quote, public accommodation. We don't know exactly what that means broadly. Is this just like government entities, you know, parks and swimming pools, or not? The answer is not. In fact, public accommodation means almost every public-facing business in the state. You do business, guess what? You're a public accommodation. Either state officials or private citizens may bring actions to enforce the law. One of these. So this woman, right, if she now says, I'm now making wedding websites, and a same-sex couple goes in and says, we'd love a website. She says no, they now have a legal cause of action. They can sue her for that. They may bring action to enforce the law. And if they're successful, penalties can follow any violation. So we don't even know what the threshold is to bring the claim. But if somebody walks in there and says, hi, we're a same-sex couple, we'd like a website. She says no, boom. I imagine that's a violation of the law. They record it and they say, oh, she didn't make a website. So then they file a lawsuit, and I don't know if she becomes strictly liable for this or what, you know, but regardless, the process is the penalty. So now she's got to defend herself and hire a lawyer and say this, you know, now social media, it's a big nightmare. So she's filing saying, all right, well, I need to know this. Like if I have to make these websites, maybe I'm just not going to go into that line of business. Maybe I'm just not going to do wedding websites. So before the district court, when they land there, Miss Smith and the state agreed to a number of facts. They did a stipulation, which is just a signed agreement. They both say, this is true. We think it's true. They think it's true. One, nobody's arguing about this. Miss Smith is willing to work with all people regardless of classifications such as race, creed, sexual orientation, and gender, and will gladly create custom graphics and websites for clients of any sexual orientation. She will not produce content that contradicts biblical truth, regardless of who orders it. Miss Smith's belief is that marriage is a union between one man and one woman. It's a sincerely held conviction. So she's not making this up. And just to be clear on this, it wasn't that she's going to just automatically deny same-sex couples websites. That's not true. It's going to be about websites dedicated for a purpose that contradicts the biblical truth. So anybody of a sexual orientation who is a same-sex couple who comes in and say, hey, we want a website. Oh, what's it for? Well, we're starting a business. Oh, that's great. What do you want on it? Sit down, sign a contract, here we go. No problem at all. But if it is somebody who comes in and says, oh, we're getting married, that's a different story, because it's her biblical conviction. It's her religious belief, and that is a sincerely held belief. And we've had a lot of other legal jurisprudence about this. You know, some people will say, you know, I smoke crack. And you say, oh, really? You smoke crack? What's that part of? Like Hunter Biden could have used this defense. He could have said like, well, it's crack's part of my religion. And they would have said, what religion is that? Crackhead religion? And they would have said, no, that's not a legitimate religion. And you don't, believe that you need crack to fulfill your religious obligations. Nice try, Hunter. But maybe the FBI bought it. Maybe that's why he didn't get charged. I don't know. We'll have to ask them. But that's not the case with Miss Smith. She provides design services that are in alignment with her sincerely held convictions. Expressive. She says when she does her work, it's original, it's customized. It is a creation that contributes to the overall message that her business conveys. Through the websites it creates, the wedding website she plans to create will be, quote, expressive in nature. And the wedding websites will be customized and tailored through close collaboration with individual couples and will express Miss Smith's and 303's creative messages, including her view of marriage. Viewers of her website will know that the websites are her original work of art. She's not just slapping up a WordPress theme, you know. There are numerous companies in the state of Colorado that offer custom website design services. Ultimately, when this case was being brought up, the district court held that Miss Smith was not entitled to the injunction. So Smith goes in and she says, hey, this law is clearly going to violate my rights. I've got free speech. I've got freedom of religion. It's all protected under the Constitution. You're compelling me to create a website for something that infringes upon my religious beliefs. I'm not going to do it. So I'm asking you, courts, to stop that law from coming into effect. There's an injunction I'm asking you to grant so this law doesn't come into effect so that I can go start my side business creating websites. But the court said, no, you're not entitled to an injunction. We're not stopping that law. Make the websites. And the 10th Circuit affirmed. They said, yeah, sorry. But the Supreme Court got this. And Judge Gorsuch, appointed by Trump, drafts the opinion. He tells us the following. The First Amendment prohibits Colorado from forcing a website designer to create expressive designs speaking messages with which the designer disagrees. That's the holding. The First Amendment prohibits Colorado from forcing a website designer to create expressive designs speaking messages with which the designer disagrees. Free speech, free religion, free exercise. Here's what Gorsuch says. The framers designed the free speech clause of the First Amendment to protect the, quote, freedom to think as you will and to speak as you think. Think as you will and to speak as you think. Very important. The freedom to speak is among our inalienable rights, unless you're on a social media platform or an FBI agent. The freedom of thought and speech is indispensable to the discovery and spread of political truth. It's true. That's why they want to censor us. For those reasons, if there is any fixed star in our constitutional constellation, it is the principle that the government may not interfere with an uninhibited marketplace of ideas. This court has previously faced cases where governments have sought to test these foundational principles. In another case called Barnett, the court held that West Virginia's efforts to compel school children to salute the flag and recite the Pledge of Allegiance invaded the sphere of intellect and the spirit, which is the purpose of the First Amendment, to reserve from all official control. State authorities had transcended constitutional limitations on their powers. In another case, the court held that Massachusetts and their public accommodations statute could not be used to force veterans organizing a parade in Boston to include a group of LGBT people, because the parade was protected speech, and requiring the veterans to include voices they wished to exclude would impermissibly require them to alter the expressive content of their parade. Okay, so these are other cases the court is referencing. They've said we've already ruled on these things previously. And in another case, in Boy Scouts of America versus Dale, when the Boy Scouts sought to exclude Assistant Scoutmaster James Dale from membership after learning that he was gay, the court held the Boy Scouts to be an expressive association entitled to First Amendment protection. The court found that forcing the Scouts to include Mr. Dale would undoubtedly interfere with its choice not to propound a point of view contrary to its beliefs. Gorsuch continues. He says, you know, all of those historical precedents have meaning. There's logic behind them. There's something called stare decisis in the law, which means we're trying to build upon other cases. We're trying to have some consistency and logic over the era of hundreds of years. We don't want courts to act like Congress and to act like they can just manipulate things all over the place and just waffle from court to court. There should be consistency because these are principles that are rooted in inalienable rights that are all beneficial for society, like free speech, like free association, like free religion. These things are incredibly important. And so if you're coming from that base layer, you shouldn't deviate too far off of those. Gorsuch says, with all of that in our case precedent, these cases illustrate that the First Amendment protects an individual's right to speak his mind, regardless of whether the government considers the speech sensible and well-intentioned or deeply misguided, and likely to cause anguish or even incalculable grief. Generally, the government may not compel a person to speak its own preferred messages. That's compelled speech. So applying these principles to the parties' stipulated facts, the court agrees with the 10th Circuit that the wedding websites Ms. Smith seeks to create are as pure speech as protected by the First Amendment under this court's precedents. The websites are speech. Ms. Smith's websites will express and communicate ideas, namely those that celebrate and promote the couple's wedding and a unique love story, and those that celebrate and promote what Ms. Smith understands to be marriage. Speech conveyed over the internet, like all other manner of speech, qualifies for First Amendment protections, unless you're outsourcing it to the big tech companies like the FBI did. Then they don't really care about those protections. Literally, they don't care. They just outsource it. And the court agrees with the 10th Circuit that the wedding websites Ms. Smith seeks to create involve her speech, a conclusion supported by their stipulations. The government, or in this case, the government of Colorado, even agrees, including that Ms. Smith intends to produce a final story for each couple using her own words and her own original artwork. And while Ms. Smith's speech may combine with the couple's in a final product, right? The couple's going to come in and say, these are our names and this is what we want. An individual does not forfeit constitutional protection by combining multifarious voices. Just mashing them together doesn't automatically make her non-protected under the Constitution. Gorsuch continues. He says, Ms. Smith seeks to engage in protected First Amendment speech. Colorado seeks to compel speech that she does not wish to provide. As the 10th Circuit observed, if Ms. Smith offers wedding websites celebrating marriages that she endorses, the state intends to compel her to create custom websites celebrating other marriages that she does not. Colorado seeks to compel this speech in order to, quote, excise certain ideas and viewpoints from public dialogue. The elected bureaucrats want to excise certain ideas. Indeed, the 10th Circuit recognized the coercive elimination of dissenting ideas about marriage. They said that that was Colorado's very purpose in seeking this law. But while the 10th Circuit thought that Colorado could compel speech from Ms. Smith, consistent with the Constitution, this court's First Amendment precedents teach otherwise. In other cases, the ones we just talked about, Hurley, Dale, and Barnett, the court found that governments impermissibly compelled speech in violation of the First Amendment when they tried to force speakers to accept a message with which they disagreed. Here, Colorado seeks to put Ms. Smith to a similar choice. If she wishes to speak, she must either speak as the state demands she speak or face sanctions for expressing her own belief. Sanctions that may include compulsory participation in remedial training, filing periodic compliance reports, and paying monetary fines. This is an impermissible abridgment on the First Amendment right to speak freely. So she doesn't go in there. She's opening up this new website service. Same-sex couple comes in, make my website. She doesn't file this lawsuit. She says no. They sue her because she's not clarifying her rights. She loses the lawsuit because everybody in Colorado, even the district court and the Court of Appeals there, 10th Circuit, agreed. Said, no problem. You are compelled to do this. So she loses her lawsuit after she is sued, and then she faces sanctions, theoretically. Mandatory retraining. You're not woke enough for us, so you got to come in here and learn more. You're going to be accepting this. Let me explain to you why the Bible and your beliefs are wrong. Stop being a bigot. Get back out there and make those websites. And we want to check in with you. So every quarter, we want to see how many same-sex websites you've made. And you're also going to pay monetary fines on top of that for not speaking appropriately. Under Colorado's logic, the government may compel anyone who speaks for pay on a given topic to accept all commissions on that same topic, no matter the message, if the topic somehow implicates a customer's statutorily protected trait. It would be nuts. Taken seriously, that principle would allow the government to force all manner of artists, speechwriters, and any others whose services involve speech, like yours truly, to speak what they do not believe on pain of penalty. The court's precedents recognize the First Amendment tolerates none of that. To be sure, public accommodation laws play a vital role in realizing the civil rights of all Americans, and governments in this country do have a compelling interest in eliminating discrimination. This court has recognized that public accommodations laws vindicate the deprivation of personal dignity that surely accompanies denials of equal access to the public establishments. Gorsuch says, over time, governments in this country have expanded public accommodation laws in notable ways. Places like Colorado's and their statutes grow from non-discrimination rules in the common law, sometimes that we saw in hotels and restaurants. Those enterprises oftentimes exercise something like monopoly power, but states expanded their laws to prohibit even more forms of discrimination. Today, Colorado, approximately half the states have laws like Colorado's that expressly prohibit discrimination on the basis of sexual orientation. The court has recognized this as unexceptional, saying states may protect gay persons just as they can protect other classes of individuals in acquiring whatever products and services they choose on the same terms and conditions offered to other members of the public. And there are no doubt innumerable goods and services that no one could argue implicate the First Amendment. But at the same time, the court has long recognized that no public accommodations laws is immune from the demands of the Constitution. And so, for example, like if you wanted to go and discriminate against somebody in a grocery store, for example, that would not be appropriate because that does not implicate free speech rights. Let's say I'm not going to make a website for you, but you can buy a computer from us and make your own website because one implicates speech, the other does not. You can buy our software and create your own website, but we're not going to do it because I have to mix my speech with the product to create the site. In particular, this court has held public accommodation statutes can sweep too broadly when deployed to compel speech. As in those cases, when Colorado's law and the Constitution collide, there can be no question what must prevail, the Constitution. And as the 10th Circuit saw it, they said, Colorado does have a compelling interest in ensuring equal access to these goods, and no option short of coercing speech from Smith can satisfy that interest because she plans to offer other unique services that are by definition unavailable elsewhere. In some sense, of course, her voice is unique. So is everyone's. But that hardly means a state may co-opt an individual's voice for its own purposes. The speaker in the other case, Hurley, had an enviable outlet for speech, and the Boy Scouts in the Dale case offered an arguably unique experience. But in both cases, this court held that the state could not use its public accommodation statutes to deny a speaker the right to choose the content of his own message. A rule otherwise would conscript any unique voice to disseminate the government's preferred messages in violation of the First Amendment. Colorado now seems to acknowledge that the First Amendment does prohibit it from coercing Miss Smith to create websites expressing messages with which she disagrees. So alternatively, Colorado is saying, well, it does kind of force her to do that. But alternatively, Colorado contends, they say, well, Miss Smith must simply provide the same commercial product to all. The same example. It's like she really isn't creating a website that is her speech. It's just a commercial product. It's just a website. She can just simply repurpose websites that celebrate marriages that she does endorse for marriages that she does not. So just, repurpose it. It's just a template. Just redo it. And so it's not actually speech. It's the same thing as buying a hard drive or a computer or pumping gas or going to the grocery store. Colorado's theory rests on a belief that this case does not implicate pure speech, but rather just a product, and that any burden on her is just incidental. Make the website. It's just clicks for you, bigot. On the state's telling, then speech more or less vanishes from the picture, and with it, any need for the First Amendment at all. Colorado's alternative theory does not sit easily with its stipulation that Miss Smith does not seek to sell an ordinary commercial good, but wants to create a customized and tailored website. She's just not throwing up a landing page. She wants to celebrate and promote the couple's wedding and the unique love story. And so Colorado seeks to compel just the sort of speech that it tacitly concede lies beyond its reach. Gorsuch says, the state stresses that Miss Smith offers her speech for pay and does so through the company, which is the sole member owner. But many of the world's great works of literature and artists were created with the expectation of compensation. So they're saying that, well, she's being paid for these websites, that makes it commercial. So therefore, she should be compelled to transact in a way and communicate in a way and do work that we want her to do. And speakers do not shed their First Amendment protections by employing the corporate form to disseminate their speech. They're like, well, it's not real speech because she's getting paid for it. Colorado urges the court to look at the reason Miss Smith refuses to offer the speech it seeks to compel. And it claims that the reason she objects to the protected characteristics of certain customers is for another reason. But the parties state to the contrary. They say, no, Ms. Smith will gladly conduct business with those having protected characteristics so long as the custom graphics and the websites that she's asked to create do not violate her beliefs. So as we said, she'll make a website for a same-sex couple for any other purpose, whatever they want. Ms. Smith stresses that she does not create expressions that defy any of her beliefs for any customers. Whether that involves encouraging violence, defaming other people, or promoting views, she's not going to do it. So the First Amendment protections belong to all, says the judge, not just speakers whose motives the government finds worthy. In this case, Colorado seeks to force an individual to speak in ways that align with its views and defy her conscience about a matter of major significance. In the past, other states in Barnett, Hurley, and Dale have similarly tested the First Amendment boundaries by seeking to compel speech they thought was vital at the time. But abiding the Constitution's commitment to the freedom of speech means all will encounter ideas that are misguided or even hurtful. Yeah, it's a bumpy world out there. People are going to say offensive things. If you don't like it, don't talk to that person. Change the channel, go hang out with a different crew. Don't do business with those people. Don't associate with those people. That's freedom. But not everybody is going to be compelled to create this world that is sufficient to your subjective experience. Sorry. Consistent with the First Amendment, the nation's answer is tolerance, not coercion. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Colorado cannot deny that promise consistent with the First Amendment, and therefore this case is reversed. 6-3 by Judge Gorsuch, delivering a nice opinion, protecting free speech, protecting religious freedoms in America. And let's take a quick look at the dissent and see where this goes. Judge Sotomayor dissenting, joined by Judge Kagan and Judge Jackson. Here is what she says. 5 years ago, this court recognized the general rule that religious and philosophical objections to gay marriage do not allow business owners to deny equal access to goods and services. Now, this court recognized that there was a stigma, but today, for the first time in its history, as they always say, grants a business open to a public a constitutional right to serve members of a protected class. That's not true. It's true in limited circumstances, but this is an overbroad statement, as we just got clear about, right? There are different things that we can pull out of the main opinion. This woman didn't just say, I'm going to refuse all gay people. That's not this case at all. It's a legitimate religious belief that combines her speech with the request of the work product, and it implicates speech. It's not something that is just a commercial transaction. Even in this case, if a same-sex couple wanted her to make a website about any other purpose, she would have done it. So this is very overbroad, and I think it is a misstatement, actually, of what the ruling is. Specifically, the court holds the First Amendment exempts, this is more specific, exempts a website from a state law that prohibits the company from denying wedding websites to the same-sex couple if they choose to sell those to the public. Now the court is facing a similar test, giving us some background on the law, and saying the legal duty of a business open to the public is to serve the public without unjust discrimination. It's deeply rooted in our history. She says, I fear that the symbolic damage of the court's opinion is done, but that does not mean that we are powerless in the face of the decision. The meaning of our Constitution is found not in any law volume, but in the spirit of the people. This is a judge talking. Every business owner in America has a choice whether to live out the values in the Constitution. Make no mistake. Invidious discrimination is not one of them. The unattractive lesson of the majority opinion is this: what's mine is mine, what's yours is yours. The lesson of the history of public accommodations is altogether different. It is that in a free and democratic society, there can be no social castes. This is amazing. These are from the same people that literally put people into buckets all day. They label people with letters and different demographics, and you can't go into certain colleges until yesterday unless you had certain checkboxes. They literally create them. This is their whole structure. And for that to be true, it must be true in the public market. For the promise of freedom is an empty one of the governments if it's powerless to ensure, because whatever, she dissents. All right. So that is the opinion. It is a good opinion because this is America. And if you want to comply with the Constitution, you have to stand firm on these freedoms. And there are consequences for this. There will be consequences for the businesses that have these beliefs. Maybe they get more business from people who are aligned with them. Maybe they get less business. Maybe People do business with people they want to do business with. That's a better structure for a free society than compelling people. You have to play nice together. You have to do this thing that you absolutely don't want to do, and we're going to force everybody to get along because some people want society to be elevated to make their subjective experience exactly what they want, all in the name of progress. It is antithetical to freedom. It is antithetical to free speech, to free religion, and the Supreme Court rightly rectified that today.